Hi, welcome to this webinar on Brexit and data protection. My name is Katie Hall and I'm a solicitor in the commercial team at Gately. For those of you that may not know, we are the main legal advisor to the Sport Recreation Alliance and have a leading experience across the entire sports sphere, from sporting clubs to brands, athletes and governing bodies, advising on a number of commercial agreements, including merchandising, licensing and sponsorship, right through to how to protect your IP and, of course, data protection. So clicking through to the next slide, you'll see my face, unfortunately, with some contact details on there for your information. So if at the end of this slide none of what I've said made sense, or you wish to get some further tailored legal advice on your data protection compliance, please don't hesitate to get in touch. There is a Brexit briefing that the SRA have put together alongside this webinar, and that does contain a more detailed note about what I'm saying today, and with some further links as well. So once you've had a listen to this, please do take a look at that, and that should help going forward with your sort of data protection compliance. I would advise as well taking a look at the GDPR toolkit that the Sport Recreation Alliance have got on their website, just to familiarise yourselves with the terminology I used today, and just to refresh your memory on some of those well-trodden GDPR data protection facts that we've all got to know and love so much. Looking now briefly at the agenda for the webinar, so you know what you've got in store, I will briefly touch upon the latest developments in the House of Commons. Obviously, as you'll appreciate, this webinar may be out of date by the time you listen to it, so apologies for that in advance. I will look at complying with GDPR once we leave the EU. That is obviously whether or not we have to comply with it or not, the practical implications of leaving without a deal, and then also what happens if we do leave with a deal, and then moving on to the important things such as transfers of data, planning ahead, and any sort of further considerations to think about. So looking at the latest developments in Parliament, obviously I apologise in advance that this is likely to change by the time you listen to this webinar, but as things stand, the UK is set to leave the EU on the 31st of January 2020. This was brought about by the EU agreeing an extension in principle to the 31st. So a no-deal Brexit has been taken off the table for the time being, well, at least until the 31st of January. But of course, the precise terms on which we will leave the EU remain unclear. And of course, we don't know whether that will be with a deal or not. So this webinar is aimed at giving you an overview of the implications for Brexit, for data protection law in the UK should we leave the EU with no deal. But of course, it will touch on scenarios in which we do leave with an agreement. So, do we have to comply with GDPR when we leave the EU without a deal? All sporting organisations are obviously affected by data protection in some shape or form, whether that's because of the data you may collect in respect to volunteers, staff, the perform analysis you do on your athletes, right through to the marketing to your members. And currently, as at today's date, every organisation that does process personal data must comply with GDPR and the Data Protection Act 2018, which you may remember was implemented shortly after the coming into force of GDPR back in May 2018. We, of course, seen all the headlines regarding potential fines that could be imposed if you fail to comply with the requirements of GDPR. But perhaps of more concern for the sports and recreation sector is that under the Code for Sports Governance, organisations do risk losing their funding for non-compliance with applicable regulations such as GDPR. So it is very, very important. So I'm sure a lot of you may be asking, surely we're leaving the EU, so none of this will matter anymore. Unfortunately, or fortunately, depending on which side of the data protection fence you want to sit on, this is not the case, and this note and webinar will aim to really explain why, give you an overview of the implications of Brexit for data protection law in the UK for sports and recreation once we leave. I would recommend accessing the GDPR toolkit, which is on the SRA's website, just to refresh your memory as I go through this webinar now. So ultimately, data protection law has been around for a very long time, but GDPR, obviously, as you know, was only implemented back in May last year, and it is an EU regulation. So you are correct, if you've been thinking so, that we will no longer have to apply with it once we leave the EU. That's regardless of whether or not we have a deal or not. So strictly, yes, we don't have to comply. Obviously, that's subject to the caveat that if we leave with a deal, we will have a transition period in which we'll probably continue to apply, have to comply with it for a short period at least anyway. But that's not to say that we don't have to do anything going forward. And those very clever politicians in Parliament have passed regulations which do make amendments to the GDPR by essentially merging the Data Protection Act 2018, which will continue to comply because it's UK legislation, and the GDPR, so that it works in a UK-only context from the day we leave. So in practice, this means that there will be very little change to the core data protection principles and rights obligations found in GDPR. So for now at least, carry on doing what you're doing because nothing really should change from a compliance perspective. So what does it mean really for your organisation practically, and what else should you be thinking about doing right now? I will come on to what this really means for data transfers to and from the EU a little bit later on, because I know that will be of some concern to a number of you. But in essence, there are sort of three things to really sort of consider going forward. As you'll see in the slide, first of all, if your organisation operates in another member state of the EEA, that's the European Economic Area, not just the UK, you will need to comply with both the GDPR and the UK GDPR after Brexit. If your organisation has an office or another establishment or branch, for example, within the EEA, that branch or office or establishment's activities will be covered by GDPR even after Brexit. And finally, if your organisation is based in the UK, but it also perhaps offers services or products to individuals who are in the EEA, or it monitors the behaviour of those individuals, you will probably still need to comply with GDPR in relation to those activities as well as the UK-based GDPR. So, for example, if your organisation's website attracts individuals based in the EU and it uses tools to monitor and analyse user preferences, for example, you may well be caught by GDPR. So just some practical things to think about there. But what if we leave with a deal? Obviously, this is the most favoured, preferable option here. In the event of a deal with the EU, the UK and EU will have negotiated a withdrawal agreement, obviously, as a basis for securing a smooth transition in the aftermath of the formal departure from the EU. The agreement will provide for a transition period during which the UK will remain subject to various EU laws, one of which will be GDPR. So that means GDPR will continue to apply in the UK and organisations won't need to take any immediate action, which will be very good news indeed. The GDPR will also continue to apply within the UK as EU law after the transition period, insofar as any EU originating personal data continues to be processed within the UK post-transition. So this is really designed to protect EU residents' privacy rights, to ensure that their resident data has been collected within the UK during such a period, such a transition period, doesn't lose GDPR protection just because the transition's ended. So things like, where an athlete, say from France, and his or her family members have relocated to the UK to further their career in a particular sport, this is where those sort of amendments and protections will apply. Those provisions will naturally fall away if the UK secures what is called an EU adequacy decision, which I'll go on to talk about a little bit in a short time. And of course, once that transition period has finished, the default position will be the same as in any no-deal Brexit scenario, as I've just talked about. But obviously, knowing our UK government, there is time for further developments on this. So coming on to the real crux of data protection and international data transfers, you may have seen various government adverts telling you to get ready for this already, so I'm sure it's sort of hot on the agenda. Firstly, taking transfers outbound from the UK, so going from the UK into another country within the European Economic Area. The UK will be a third country once we leave the EU with or without a deal. The UK government has confirmed that following Brexit, it doesn't intend to apply restrictions on transfers of personal data from the UK to the EEA. This is essentially because outbound transfers of data will be subject to the UK version of GDPR, and also various Brexit-related regulations have been passed, which will recognise all European Economic Area countries as adequate in speech marks, so permitting those data transfers to continue as before. So really, UK organisations should be able to continue to send personal data to those in the EEA completely unrestricted, and you can continue as you have been doing before. So thinking about examples of this, you may have a database that stores data for your organisation in Germany or Ireland, or you may send information about an athlete to another country for purposes of organising an event. This shouldn't be a problem going forward, and those sort of transfers won't be restricted at all. UK organisations will still also be able to continue rely on the EU-US Privacy Shield scheme to send personal data to entities within the US. But of course, this is reliant on the US entity having updated its privacy notices to expressly extend protections to transfers from the UK. So just something to bear in mind. These are all, of course, intended to be temporary measures, and in time the UK is expected to conduct its own sort of adequacy assessments for each of the EU member states. So there will be further developments going forward, I'm sure, in the next few years. So what about transfers inbound to the UK? Unfortunately, the EU has not granted similar modification in respect of these sorts of transfers. So following Brexit, transfers of personal data from the EEA to the UK will be restricted, and this is where it gets a little bit more complicated. This essentially means that any organisation will only be able to transfer personal data inbound to the UK as long as either the European Commission has decided that the UK ensures an adequate level of protection. This is what I was referring to earlier as an adequacy decision. And again, to remind yourself of what this is, for more detail on international transfers of data, please take a look at the GDPR toolkit on the SRA's website. Or the organisation has provided appropriate safeguards for the transfer. So This, in most cases, will be to adopt the standard contractual clauses, which have been approved by the EU as a legal basis to safeguard the transfer of personal data to third countries. And of course, that will include the UK after Brexit. There are templates of these documents online, again, and available within the toolkit. So take a look at to remind yourself what these are. So if you are in receipt of personal data from third parties based in the EU, perhaps you're a sports federation and relies on the sharing of like sports betting data, or for the prevention of fraud in the gambling market, something that is often cross-border, the lack of a clear route for these sorts of transfers may complicate things. However, it really shouldn't have to. Whilst every case is different, and there's no reason really that the third organisation within the EEA can't use so these standard contractual clauses. Of course, it's the EEA controller of the personal data which must comply with those GDPR rules, because they're based out in Europe. Organisations such as yourselves in the UK who want to receive the data and to, prevent any sort of impact on the flow of data may want to just give them a bit of a nudge to assist them in their compliance. In the absence of an adequacy decision, as I've just mentioned, or the establishment of safeguards such as standard contractual clauses, there are other derogations to allow the transfer of personal data to the UK or another international organisation outside the EU, but they're quite narrowly construed, and they include things like express consent from the data subject themselves, or where the transfer is necessary to perform the contract. But again, for further guidance on this, please do have a look at the toolkit or get in touch if you want to discuss further. It is important to note, although I doubt the impact will be particularly great, that standard contractual clauses cannot be used to safeguard transfers between an EU-based processor and a UK-based controller. So thinking about things like external examiners that may be based in the EU who have been instructed to assess a participant's performance on a training course or event abroad, for example, where you might have a cloud-based provider in Ireland, or a platform provider who deals with your safeguarding monitoring based in the EU. There may be potential difficulty here where you have those sort of EU-based organisations processing personal data on your behalf, simply because the standard contractual clauses are currently not fit for purpose for this sort of scenario. So it's something to sort of keep in mind. And of course, the UK does hope to secure an adequacy finding from the EU that will remove the sort of need for these standard contractual clauses and other safeguards between the UK and the EU going forward. And the EU has said it is prepared to consider this, but of course it's not right at the top of their priority at the moment. But it will be considered, although these things do take time, and it's unlikely that any sort of adequacy decision will be taken at least within the first 12 months of Brexit Day. So it is a known area of risk, one that you should be alive to and manage accordingly. So if you do have any concerns here, do pick up the phone or drop us a note, and we can discuss further. So what can you do to plan ahead? So practically, obviously, for many organisations that have just gone through a significant process of updating their contracts and other sort of documents to deal with GDPR, I'm sure the thought of me telling you now that you want to make a second wave of amendments doesn't fill you with much joy. So apologies for that, but there will be a small amount of updates to be made, albeit I don't think they're going to be huge. You will need to update references in governance records, for example, contracts and privacy notices to reflect the post-Brexit position. And this may require changes to things such as your records of processing activities, which I'm sure you've all done in compliance with the toolkit that was prepared last year. Many organisations will have conducted data mapping exercises in readiness for the EU version of GDPR coming into force, with international data transfers being a likely area of focus. So you should be reviewing those now and any sort of relevant international transfer provisions to see whether sort of any amendments are needed in the event of a no-deal Brexit. Privacy notices, amendments to these are likely to be minor, for example, to update references to relevant laws, such as changing the GDPR to the UK GDPR, and to include transfers from the UK to the EU. And these changes should be made at the time of Brexit or as soon as possible afterwards. Data protection impact assessments may need to be updated if they refer to a transfer which becomes a transfer to a third country, obviously UK being one of them after exit date, and contracts with third parties, if they include specific references to GDPR or the European Economic Area or anticipate a data transfer between the EU and the UK, these will need to be updated. Other considerations now, while we have a little bit of time to get things right. If your organisation is going to be subject to regulatory responsibilities under both GDPR and UK GDPR, obviously we talked about this at the beginning of the webinar, and whether you will be impacted. This may unfortunately result in additional compliance requirements. So taking the first point, for example, on the slide, you may need to appoint separate data protection officers for both the UK and EU. And if this role is to be combined, you'll need to ensure that any such data protection officer remains accessible from each establishment. You may need to nominate a new lead supervisory authority in the EU, as well as registering with the ICO for your activities in the UK. The ICO, that's the Information Commissioner's Office, will not form part of any post-Brexit GDPR regulatory regime, including the lead supervisory authority mechanism for cross-border processing. So just keep that in mind. Third point on the slide, you might need to appoint a local representative in the EU or EUK, where you're processing data from outside the jurisdiction. If you don't have an EU establishment, but you do offer services or goods, for example, to individuals in the EU, as we already have discussed, you may need to consider whether you are required to appoint a rep in the EU, because, of course, you will still be subject to GDPR. And finally, the last point on the slide, and possibly the most sort of unknown at the moment, is in the event of a no-deal Brexit, the UK does stand to lose its seat on the European Data Protection Board. So this is significant really for one main reason, is that the UK will no longer be a part of the decision-making process in determining how data flows work in a no-deal scenario, and they won't be able to participate in any discussions on sort of enforcement. So this does raise the prospect of organisations being fined twice, both up to the maximum penalty limits for a breach of the legislation by both the ICO and any EU-based regulator, where the same breach impacts data subjects in the UK and any EEA country, which has obviously been avoided at the moment. Of consolation, the ICO has demonstrable record of being quite pragmatic when it comes to enforcement and in factoring in, obviously, the uncertainty right now. So the size of penalties that can be imposed for non-compliance under GDPR will remain a concern, obviously, for organisations. But I should expect that there are good grounds for expecting a reasoned and pragmatic approach from the ICO and the UK government in this scenario. So thank you for listening today. I hope that the slides and the webinar have been useful. Obviously, each organisation has its own requirements, and it's very important that you take focused advice from a data protection specialist. So to go along with this webinar, on the SRA's website, there is a Brexit briefing on data protection, so please feel free to take a look for further guidance and as a more detailed note on what I've discussed today. But if you also have any other questions, please get in touch with Gately Legal's data protection team, myself or someone else, and we will be happy to help. Thank you for listening.